Good morning, everybody. First off, I'd like to welcome everybody and thank you guys for joining us with us. My name is Kevin Ware. I'm president of Saguaro Environmental. We are excited to bring this information to you guys. If you can, or if you have any questions, feel free to type them in. I've got an ability to see if you guys have any questions. What we're going to try to cover today is basically what are phase ones, when are they needed, what to look for, those kinds of things, because on our side, dealing with the environmental issues, clearly there's a lot of things we see that you guys on the deal side may not. And so hopefully today you can get a little bit of information on what is a phase one, when are they needed, some terms that we commonly use when we do the phase ones, and we can kind of go from there. But again, thank you for joining with us, and we look forward to giving this information to you guys. So bear with me for just a second. I've got to see if I can get this to pop up. So I apologize. This is kind of new to us. All right. Well, first off, again, thank you, as I mentioned before. So really the phase one is kind of a unique, it's a unique idea in the sense of it helps to protect, or the intent is to protect both buyers and sellers, banks, and everybody, those who are involved, because a lot of the time, as you guys know, when you start in on a deal, sometimes there's property that has either had issues in the past or something like that. And so the purpose of a phase one is really to kind of help document and provide a vehicle to help protect those involved from what may be current or even historical environmental issues. So with that being said, like I said, we'll kind of cover what are phase ones. Well, they really are the process by which a person or an entity seeks to see if the property that is in the deal has got any what we call recognized environmental conditions. And with that being the main focus of what we're looking at, the REC is really the summary of what we find in a phase one. That's going to be the heart and matter of the reportable issues. So when we complete a phase one, we complete it with the understanding that we're doing both current and historical research on a piece of property. That again is done through a series of steps that we employ in order to identify if there's anything that may be of concern that could cause a devaluation in the property. There's things that we also do to look at whether or not the contamination may have moved, if there is any on the site, off-site. There's several things that we have to look at. And so, and I see a couple of you guys, welcome. Again, I apologize if I'm starting a little bit early, and we can definitely wait for a few more people, but the phase ones are really, they're a really good tool in terms of helping understand what people are going to be struggling with in terms of the environmental background of a piece of property. So for those of you who are just joining us, again, my name is Kevin Ware with Saguaro, and I appreciate you joining us. If you want to, you can always type in a question, and we can definitely answer them. And if you want, we'll provide our contact information at the end of the presentation, and you guys are more than happy to reach out to us, and we'll see what we can do to help you. So to the question is, what are phase ones? Well, phase ones are an ASTM, or American Society of Testing Materials, derived protocol by which people do research on a piece of property to see exactly what kind of concerns have come up from an environmental perspective. And that can be anything from contamination on the surface to contamination underground and contamination on adjacent pieces of property. So whenever we do the research, we're really trying to identify what those issues are that could affect, again, the valuation or even the cost of a piece of property, that could affect also cleanup requirements on the back end that may be extremely onerous for someone to have to take on in terms of dealing with the state as well as contractors and so on and so forth. So again, that's kind of what are a phase one right off the start. So with that being said, I'm waiting for this to kind of catch up. Under the Comprehensive Environmental Response, Compensation, and Liability Act of 1980, we commonly refer to it as CERCLA. It provides, phase one provides the basis for liability to defense for purchasers who demonstrate proper due diligence prior to acquisition, on-site and off-site. Because again, we're not just looking for the issues that are occurring on the property, but we're also looking at what may be on adjacent pieces of property that could affect the cost or whether or not there has to be cleanup or something like that. And recently, the ASTM, or American Society of Testing Materials, came out with a new update a couple of years ago, and that update is codified in standard 1527-13. There are some contractors out there that do phase ones that do not meet the standard. And so actually, unfortunately, if they do not meet the standard, a lot of those are going to be considered more or less useless at the time of a transaction, because if attorneys get a hold of it and it doesn't meet the standard, it doesn't rely, you can't rely upon it for helping a closure of any type of a deal. So it's important to understand what the requirements are of ASTM, and we as the environmental professionals are required to do such a thing. So again, the ASTM came out, and there's been several versions of it, but the most recent version is ASTM 1527-13. And it's a very comprehensive format of all the things that we have to look at. And clearly we won't get into every single one of those details today, but for purposes of understanding it, that is the guiding authority that we have to answer to when we complete a document. So I guess one of the first questions you guys probably ask all the time is, well, when is a phase one necessary? Well, we tell people prior to any kind of really commercial transaction, it's important to think about whether or not a phase one is going to be appropriate. Sometimes I know banks will say the minimum is based off of a deal value. In other words, if it's not $1 million or more, we won't engage a phase one. Again, we kind of look at it from the perspective of if there's even the slightest chance that there's potential for any kind of contamination or worry about it, it's best to go ahead and complete a phase one. And the reason why is because to get what we call protection under the CERCLA Act, you have to actually follow the steps, and the phase one is the first step in that. So the CERCLA Act is just merely that, it's a vehicle for it, but if you don't follow the steps outlined into it, then the purchaser or the lender do not get the protection that they want in order for the deal to occur. And so the phase one is kind of the first part of that entire plan. So we tell people anytime that you're looking at doing a piece of property, whether it's a loan or whether it's a real estate deal, it's good to consider the need for a phase one. There are other shorter versions of it, but unfortunately the CERCLA, or getting protection underneath CERCLA, is limited because it doesn't allow you to claim immunity under that Protection Act if you don't follow the steps. So again, when is a phase one necessary? Both to get protection from CERCLA, as well as when a property owner wants to know the environmental history of what the property is and if there's going to be any costs associated with it. Oftentimes we've seen phase ones occur when there's a refinance, inheritance, donation. Anytime there's any kind of transaction, it's suggested that we always look and see if there's going to be ramifications that could affect not only the deal itself, but if there's going to be long-term costs for a property owner, and say that there's a big cleanup on the property or adjacent sites that they could be looped in on, the phase one helps identify that and gives it kind of a name and a value as far as what that looks like. So again, it's all dependent upon the value of the deal, but right now we basically say that a phase one is really needed on any kind of commercial transaction, whether it be raw land or whether it be improved land with buildings or an industrial building. That's kind of our suggestion, but clearly everybody kind of sets their own tempo of what defines the need for a phase one. So one of the first things that has to be outlined is who is an environmental professional. Well, an environmental professional is, at least based on the ASTM standard, a person who possesses the training and experience in order to be able to assess accurately what's going on. Clearly, there are people out there who sometimes say that they can do phase ones and may not have the background or the education or licensing to do such a thing. I'm a licensed engineer myself, and we have other people on staff that are all carry certifications and have 15, 20 years of experience. But one of the first things that I've seen disqualify phase one is whether or not the person who conducted it or oversaw the investigation of it did not have the years of experience associated with it. And that's not to say that they're not good or bad people, but the standard is pretty explicit about the fact that those who conduct these should have a background and training and licensing in this area. So one of the first things that, again, attorneys will look at is what are the qualifications of the person who is signing the report. So that the new standard that came out, the 1527-13, again, that's really, excuse me, it's going to help define a little bit more of what the environmental professionals' experience requirements are. And that's going to help weed out a lot of people who are trying to do these that don't either have the insurance, which I know is important for you guys, as well as the background. So to that effect, that's kind of the first question right out of the chute is who has the qualifications. So again, we kind of come back circle to the purpose of the phase one is to evaluate the property for contamination. Excuse me. And the contamination is, it can be in all types of issues. It can be anything from asbestos to lead to underground storage tanks. And we'll show you guys some pictures of what that looks like and things that might kind of give you a red flag. But well, like I mentioned before, the issues that we identify in the phase one, the problems can range from a $10,000 cleanup to $250,000 for a gas station that can take years to close out with the state. Oftentimes, if we find contamination or presence of historical contamination, some of these sites have been in programs for literally 10 or 15 years. So it's important that people who are buying or selling a piece of property understand that requirement, that if there's ongoing types of cleanup activities or something like that, there's a cost associated with that. And so again, the purpose of doing the phase one is to figure out what those issues are and also to get the circle of protection. So one of the key terms that jumps right out at the beginning of any type of a report, and so a lot of the time we focus on the creation of the report. And all of the background documents in the report are important, but I think for what most people look at is the executive summary. In the executive summary, we look at and we analyze if there are on-site issues based on our records research that is done. We're supposed to go back to, I believe it's 1942, and we have to look at various sources, whether it be from historical aerial maps, as well as a full-on records database analysis with the government databases, and so on and so forth. And we use all of those assets, if you will, in doing the phase one to identify what we call an REC, or a recognized environmental condition. Excuse me. And so the REC is the presence or likely presence of any hazardous substance on a property under conditions that may have a release, whether it be past or present. And primarily we're looking for anything that is of hazardous substance or petroleum that is on the property, in the ground, or surface water of the property. So oftentimes we'll go out to the sites, excuse me, and we will find that there's been a lot of staining on the ground from, say, maybe an oil change place, or maybe there's been an oil and grease trap on a piece of property. That sends up red flags to us, because what that does is that tells us that we've got concerns that maybe there's a past spill, maybe there was an issue that never got cleaned up. And so those types of indicators, whenever we do the site visit and we look at the records, provide kind of a basis for understanding of whether we really have a REC, or recognized environmental condition. So once we've identified those and what those are, a lot of the time they are become the backbone of discussion moving forward with the deal. And so anytime a phase one has identified what we call RECs or RECs, the first thing that has to be done is to be able to understand what that means for further investigation. So a lot of the time when we identify a REC, it's either with the understanding that we're going to do further investigation and we're going to do some more analysis, or we even might go to what they call a phase two, or a limited investigation, where you start drilling on the property. The important part that I want to make sure that everybody understands is that on an REC in a phase one, that does not involve any field sampling of any kind of materials or anything else. It is purely an assessment or an evaluation by the environmental professional based on information that we identify. So the phase two, as I just mentioned, is kind of the next step. If we find an REC that warrants additional investigation, oftentimes we'll support, or we will recommend, if you will, for someone to conduct drilling or to take soil samples or to figure out where the contamination is on the surface, or if it's underground, kind of what we may have. So if there's been underground storage tanks, again, oil and grease traps, they may have leaked over time and caused subsurface contamination, which gets real expensive to clean up. So the first thing to look for in any of the phase one is an REC. So that, and they're usually outlined in a executive summary, and it should be pretty explicit as to the nature of why it's being determined, because we as the environmental professional are under an obligation to identify those in the report, and then the next steps can kind of be discussed as to what makes sense based on what's going to happen with the property. So the other term is you'll hear people refer to as historical recognized conditions. That is something that happened in the past. It would be recognized today, but it may or may not be the situation currently. We generally don't identify a lot of HRECs. Most of the times, if we see something on a piece of property in a phase one, it's going to be just a current REC. In other words, we're not going to identify or situate between a historical REC and a current REC. It's really kind of all the same. So a lot of the time, I don't know that I've personally or we've ever used HRECs on any of the reports that we've done. We either figure out that there's a problem or it's a clean piece of property, and that's what we move on with. So if you see that in somebody else's report or in our report, that's kind of the basis of the meaning of what that looks like. So the other option is, again, a controlled. Well, this is oftentimes when you see whether contamination is ongoing, or it's been identified by either a prior consultant or somebody else who's working on it. And it was attempt that the EPA as well as ASTM came through, and they tried to put this term out there because, as it's outlined here, is attempt to address contaminated sites that have received regulatory closure. So you can have no further action or there's no further remediation, but the residual contamination and the property can still be subject to what we call AULs, or activity and use limitations. So oftentimes there may be a time where you do a deal where somebody has had contamination on a piece of property, and say they did an investigation back into the history of the site, and it came up that there was an old underground storage tank and it leaked for years and years and years. And the state has been involved in terms of any kind of a closure program or cleanup assessment. And in doing so, that program that the state is mandating the investigation and characterization of the contamination, at some point they may either say, okay, it's the what we call a plume, which is the contamination underground and how it's moving. Maybe it's stabilized, it's not moving anymore. But there are some times where you have to monitor it over a certain period of time just to ensure that it's slowly degrading over time. Or even sometimes there's active equipment on site that is meant to treat the material, especially in groundwater. So a CREC is something when we find where we say, yep, there's been contamination, and that contamination is being either taken care of through treatment means, or it's being controlled through further analysis with the state in terms of historical contamination and where it's at today, and maybe even sometimes a future as far as monitoring it and taking quarterly assessments on the groundwater and the soil. Oftentimes we've seen the fact that if there is contamination on a property and it's been controlled, we oftentimes recommend that people will put money aside either into the deal through an escrow account or something like that to help cover the cost of what the continued monitoring might be for the next 2, even 3 or 4 or 5 years. So depending upon the deal, that can be a negotiating item to where if there is something that's been identified, it could be used at a later date to help kind of negotiate either value reduction or value adjustment based on how much money might be needed in order to set aside for cleanup activities. So if you see that term, that's kind of what that term alludes to. So I kind of touched on it a little while ago. EPA got involved here probably about 5 or 6 years ago. And at the time, ASTM was really the only authority that was issuing guidance on how to do a phase one. And then EPA looked at it and said, yeah, they wanted their say in it as well, because it's a lot of it is dealing with environmental contamination on sites that they have oversight with. So one of the things they came out with is what we call all appropriate inquiries, okay? And it's actually part of the codified rule of EPA. So when we do phase ones, we both have to meet what they call all appropriate inquiry, as well as ASTM 1527-13. So the all appropriate inquiry is the same thing as a phase one, but it's kind of interchangeable in terms of its use. However, there are certain other restrictions and other guidances that are regulations that oversee all appropriate inquiry. And one of the things that it does provide is it does provide a couple of different opportunities to protect people, whether it be from the lender side or whether it be from the purchaser side. And we'll get into those in a minute. But really, the all appropriate inquiry does identify whether you can be what they call a bona fide prospective purchaser, innocent landowner, contiguous property owner. And one of the things the phase one does is it does provide that legal means of identifying what those are prior to acquisition of the property. So again, it all starts with the phase one. Sometimes we have people that will come to us and say, yeah, I know there's contamination on the property, go ahead and go drill it and figure it out. Well, if we skip to a phase two, you can't get protection underneath the CERCLA Act, or especially all appropriate inquiry. You have to follow the steps, and they tell you the first thing is to do a phase one. Hence, why are they necessary? So again, the all appropriate inquiry, you'll see that in some of the reports. That's based on the EPA's involvement and what they had to say regarding those types of activities comparable to ASTM. So this is something that may be of interest to a couple of people, especially to some banks and whatnot. And I don't know that a lot of people talk about this all the time, because again, the question is often asked is, well, what kind of, or what's needed for a phase? Well, these reasons are what provide that backbone for helping with that argument. So I think the thing that we can look at is if you can do the phase one, you might be able to claim under an exemption called the innocent landowner exemption. And with the innocent landowner exemption, it allows you to get protection. And so in other words, the qualifications are is that identified in the phase one, whether or not the landowner caused or contributed to hazardous substances, knew anything before completing it, and had no reason to know of threat and release. If you can qualify for that exemption, it keeps you out of the chain of title and dealing with having to deal with all the cleanup costs. But the one I think that we see more people use than anything else is the bona fide prospective purchaser exemption. So in other words, if you buy a piece of property, and this is on any property, whether it be an apartment complex or a dry cleaner or anything else, and you acquire ownership after the date and hazardous substances have been released prior to the purchase and no potential liability or connection with what we call the PRP or potentially responsible party other than through the purchase agreement, you can claim exemption and protection underneath that. So it's a pretty powerful tool in terms of being allowing people to get protection beyond just of, well, am I going to be responsible for it? Is it going to be under my cost structure to have to deal with that? So one of the things is again, and a lot of the time the designation or assignment of either this innocent landowner exemption or the bona fide prospective purchaser is often done with the aid of legal counsel who has experience in doing such things. So the bona fide prospective purchaser exemption is clearly a powerful tool for that. There's also a continuous landowner exemption. So say you buy a piece of property or one of your clients buys a piece of property and it's adjacent to a site. Okay, well, if the adjacent owner did not cause, contribute, or consent to any of the releases, and after completed, didn't have any release of it, and you can kind of read through it, then you can claim exemption under the contiguous landowner. So just because your neighbor has a problem doesn't mean it has to become yours. It's kind of the message we try to tell people. So these are 3 of these, and there's clearly a lot more information that can be involved with those. So we just wanted to bring it to everybody's attention because, again, substantiation for doing a phase 1 is rooted in these types of protections that not a lot of people talk about. So coming up in the next probably month or 2, we're going to offer up another webinar and really dive into these and how you can claim it, what you can get from it. But a lot of the time people on both sides of the deal don't understand that these are available. So we again, just wanted to mention. So to kind of get into the heart of the matter, what is a phase 1 and what breaks it up? So as I kind of touched on it, it deals with records review, site review, interviews, and then ultimately the report. The records review is kind of a standardized, there's government databases that we have to look through, whether it be fire insurance maps and whether there's been a spill on the property or adjacent to it, and so on and so forth. So a lot of the time you'll see a big chunk of the phase 1 report has nothing but data from everything back to 1955 on up or 1940 regarding the site and adjacent pieces of property. So what we do is we take that information and we actually go out to the site. And the site visit is probably the more important than anything out of this, because one of the things that a trained or qualified person will do is go out to the property and actually make a walk around and take pictures and identify things that could become an REC. And so we'll show you some evidence of things that we see that not everybody may identify when they're walking a piece of property. But the other thing is interviews are also extremely important. So one of the things we stress in doing the phase 1 is to talk to the landowners and things like that. There's actually an environmental questionnaire that has to be completed at the beginning of a phase 1 so that anybody who has knowledge can kind of come forward and have the opportunity to tell whether or not they know what that is or what the source of the issue is. But more times than not, we'll talk to people on properties, say it's an old car wash or something like that. We'll talk to the guy who maybe owned it or installed the original car wash system. And we gain a lot of information from talking to people as whether there was an issue before or there might be now. So interviews are extremely important to the overall assessment. And then again, the report is really kind of the backbone and the legal definition or legal means by how the property is assessed and the phase 1 is completed. Phase 1s are good for up to, I believe it's 180 days. And then after that, a new one has to be completed. So the rules are pretty specific. The fact that you can rely upon a phase 1 that's been completed within that time frame, but past 180 days, we or anybody else actually should complete a new or current one because things may have changed on a piece of property. Maybe they built something or we don't know. So the reports, oftentimes people say, well, why can't I just use this report that was done 2 or 3 years ago? The standard does not allow for reliance upon the report in terms of any kind of legal defense. So again, these are real kind of broad and excuse me, broad sweeping elements of what you see in a phase 1, but they're all important because if not one of these is there, then it doesn't meet the standard, again, that's outlined in 1527 or the all appropriate inquiry. So moving on to kind of, again, things that we see that are kind of funny we laugh at it, but most people don't even realize it. But a lot of the time, clearly there are things that you look at and go, yeah, that's a problem. Sometimes people don't understand that. We've been to sites like in the lower left-hand corner where you've got drums and people have got kitty litter out and they go, I don't get what the problem is. But floor drains in facilities, especially ones that have been operating for a long time, scare us to death. Because usually we don't know where the floor drains go, and oftentimes people dump things into them literally just because they were lazy and didn't want to deal with it. So a picture says 1,000 words, and so a lot of the times when we do phase 1s, the pictures are the backbone of how we defend of whether or not our opinion of whether a property is clean or whether it's got an issue. So these are some ones that we've seen before, and as you can kind of tell, people are lazy, and it's amazing. And even today, you think with all the years of an EPA and everything else that nobody would keep doing this stuff, we see it every day. People just seem to somehow mismanage and think that these types of things are not applicable to them, and that's what causes all these problems. One of the things that is really kind of a big indicator for us when we go out is we look for things like vent pipes. So underground storage tanks are really the first and foremost issue that we look at as to whether or not there's going to be a problem or an REC in a piece of property. And the vent pipes, kind of like you see in the upper right-hand corner, that's a red flag to us. And we've been to a couple sites, and we went to one recently where it was in the back of a building, and there was a very, very small pipe, and it actually someone had taken a milk jug, cut it out, and stuck it on top of it as a means to keep the rainwater out. But it was a vent pipe. So that's something that we look at in terms of underground storage tanks. We also look for ASTs, or above ground storage tanks. And so you can kind of see in the middle, sometimes people will keep used oil in tanks and stuff like that. And most of the time, again, it's spilled over the years and left a lot of issues. So sometimes we may call an REC on an above ground storage tank because it may have leaked over time, and we have concern about how much contamination may be underground. So these are kind of, again, examples of what that looks like whenever we look for an REC. So I think that's it for today. I was trying to keep it for about 30 minutes. And again, for the people who've joined us, thank you so much. And we've got our contact information, which we'll email out to you guys. And I think if you've got our email, you've got our contact information. One of the things that we're trying to do is kind of expand our footprint. And these are some of the additional things that we do offer in terms of services, to where if beyond just the phase one, if we have to get into things of other consequence, such as wetlands or stuff like that, we take care of that all the time. So again, thank you guys for joining us, and we're looking forward to working with everybody. And if you have any questions, feel free to reach out to us anytime, and we'll post this on the website at some point. So hopefully everybody can kind of check in and see what it's about. But look forward to some more coming up in the next couple of months, and we'll dive farther into the world of environmental and real estate and what that means. So again, thank you for your time.